Hey guys, let's talk about what do you do when portfolio recovery calls you, writes you, credit reports, or sues you? What do you do? Hey, my name is John Watts. I'm a consumer protection lawyer and I appreciate you watching this video. If you've not subscribed, feel free to subscribe. We put out new videos every day. So let's talk about portfolio recovery. This is probably the second biggest debt buyer or debt collector out there. Just a huge company based in Virginia. And they do all the things that I mentioned. They make phone calls, they send letters, they credit report, and they sue. And when I say they sue, I mean there are times in Alabama, just Alabama where I practice, 1,000 lawsuits a month. I mean, just a staggering number, given our population. And so you picture that all across the nation, unbelievable amount of lawsuits. They credit report on way more people than that. They send letters on more people than they credit report. And they call even more. So let's kind of go through this quickly. What are some options? So again, call, write, credit report, sue. So let's start with calling. Well, when they call you, you don't have to answer, but I advise you to answer. I think it's a good idea for consumers to answer if you are in a place where you can make good notes. Okay. And so what do? Well, let's understand their mentality. When they're on the phone, their sole objective is to get money or a promise to pay. They don't get any extra credit for, realizing, oh, you're in a difficult situation. We're not going to try to collect against you, or, oh, we got the wrong person. That they may say that they like their employees to do that, but that's garbage. I mean, they are trained and they are evaluated on, did you get a payment or a promise to pay? Well, what's your objective? Your objective is totally different. When some debt collector just calls you on the phone, okay? What's your objective? Is to be like a reporter, okay? Who, what, when, why, where, how, those types of questions. Who are you? Why are you calling? What is this about? When did you get this debt? How much is it? What do you say that I owe? Are you going to credit report? Are you going to sue me? You just ask all these questions. And I was describing this sometime years ago, and this lady I was talking to said, so you're saying be like a 5-year-old where you're just like constantly asking questions. I'm like, yeah. Now, we're not doing it to bother them. We're doing it to gain information. Use this call that comes in not to be sort of back on your heels and like, oh, I'm on the defensive. But what I want you to have the mindset of, you don't have to say this, okay, out loud, but in your mind go, this is great. I'm so glad you called. I got lots of questions. Let's get started, okay? And so you flip the tables on them where you're just asking them questions and you're using this as an opportunity to gain knowledge because that will be helpful to you. And then you end that call. I would never agree to pay these guys over the phone. When they just call you, you say, look, send me proof in writing. Here's my address, send me proof in writing. And then you can see, is this legitimate? Is it really portfolio recovery? Who is it? And so that's what I would do on the calls. Make really good notes and then get with a consumer protection lawyer because there are enough times where those calls violate the FDCPA, the Fair Debt Collection Practices Act. Either they're being harassing, they're lying to you, they're being unfair to you, and we can sue them for that. And that is the best type of call when they end up getting themselves sued. And so the debt's going away because that's typically what they do in a settlement. At least if they want to settle with my firm, the debt has to go away, has to come off our credit report, and they've got to pay money. Okay. Well, what about if they send you a letter? You open up, get this envelope, like, what is this? You open it up, hey, we're portfolio recovery. We bought this Synchrony bank account. You owe us this money. Here's a deal we're offering. Well, what I would do is within the 30 days that you got that letter, and I try to make it sooner than later, I would send them a letter, sometimes called a validation letter, verification letter, dispute letter, all different names for it. But basically it's a letter that says, I dispute owing any debt to you. I want you to send me proof. Well, what proof? Well, it depends. Is it a credit card? You'd want to know, when did you take out this credit card? What are the terms of the credit card agreement? Because that's going to tell us the interest rate, the late fee, the over the limit fee, and then all the statements from a zero balance. Now, obviously starting off as zero, but you may have, sort of incurred debt and then you paid it off to zero. Well, they could start there. Okay. Zero balance to where we are now. I want all the statements so I can see what are the charges, the fees, the credits, the payments, the interest rate. How do I know that this is right unless I have all those statements? They should have them because they're claiming, sort of draw a line under that word, claiming to own your debt. Well, if they own the debt, they should have all the statements, right? Pretty simple. Give me those statements from the last zero balance to where we are now that you're claiming I owe you $4,327, okay? And then you say, look, portfolio, you claim to own this debt. Send me a copy of what's called the purchase agreement where you bought the debt. I want to see that. I don't know who you are. Show me the purchase agreement so I can see if you really did buy this debt. Now, they won't give it to you, but we're laying a foundation for later on. Maybe they sue you, and that can be very helpful. So we're kind of planting a seed here, and that may then be very fruitful for us down the road. Okay. Then you see what they respond to you with. And then you get with a consumer lawyer. Hey, are they doing this right? Are they doing it wrong? Can we sue them? I've sued Portfolio Recovery before because this was a debt that was like 8 years old that said, we may credit report on you. No, buddy. You ain't credit reporting on me. I supposedly defaulted 8 years ago. It's too long to credit report. And then they say, we may credit report. May means that it's possible. No, it is impossible. Zero chance of you credit reporting. And so if you threaten me with that, I'm going to sue you for that. So that's why, again, I say, take that letter and then your validation, dispute, verification letter, and then how they respond to you, and take that to a consumer protection lawyer. Now, when you send out the letter, obviously make sure you do it by certified mail so you can prove that they got it. All right, so what happens next? We've talked about them calling you, writing you. What if they just show up on your credit report? Maybe they haven't been calling, they haven't been writing, but they're on your credit report. Well, you have a couple options. You could dispute through the credit bureaus if you can find errors on there, okay? But you've got to be able to identify those errors for the credit bureaus. I think the better approach is you just send a letter to Portfolio. Again, send it certified. And you say something like this. I dispute owing any debt to you because I have no idea who you are. And I refuse to pay you because I don't know who you are. Thank you very much. Okay? It could be that simple. I refuse to pay you on any debt because I don't know who you are. And I dispute these debts because I don't know who you are. And now what that does is now Portfolio has a couple options. Will they respond to your letter and say, oh, well, let us explain who we are so that you can pay us? Well, guess what? They just violated the FDCPA, the Fair Debt Collection Practices Act. Because when you say, I refuse to pay, that is a cease communications request. They have to honor that. And so if they try to collect by writing, by calling you, and there's a slight few exceptions on the writing, okay, if you get to that point, sit down with the lawyer. But if they contact you, then they violate the law. Guess what? We sue them. Debt goes away, comes off our credit report, they pay money, okay? Well, what if they say, all right, we're not going to write you or collect on this, but we're going to continue to credit report? Well, when they update every week or every month, then did they mark your account as being disputed? Because that letter also said, I dispute any debt to you. So they get your letter, and then let's say a week later, 14 days later, 21 days later, they update your credit report, and they don't mark it as disputed. That violates Section 1692E8. And then another month goes by, and they don't update it as reported. They update it, but they don't show it as disputed. It's another violation of Section 1692E8. And so then again, you sit down with the lawyer, we sue Portfolio, they come off our credit report, debt goes away, they pay money. Okay, it's a great outcome. Now, how about if they sue you? Well, the biggest danger people face when they are sued is that they do nothing and there's a default judgment against them. So you've got to respond, however your state says to respond. I think in Florida and small claims court, maybe if you don't have a lawyer, you just go there in person, or now it's done virtually. Okay, I don't practice in Florida. You figure out in your state, you have to file an answer. In Alabama, where I practice, we have to file answers. Okay, so it has to be submitted to the court, the clerk of the court, a written answer. Maybe your state's different. Figure out your state. How do you respond? What's the timetable to respond? Do you have 14 days, 21 days, 30 days? How long do you have? You got to know that. Okay? You have to know when you've been served, because that's what starts the clock ticking to do this. All right. So you say, well, what do I say in the answer? And should I do this on my own? Should I hire a lawyer? 5 options that we've been teaching and preaching for, 15, 20 years now. And they haven't changed. These are still your 5 options. And I recommend everybody go through these 5 options. Number 1, consider bankruptcy. Now, I don't file bankruptcy. Maybe 1 out of 200 people that are sued who call us do I recommend bankruptcy. But it is an option, okay? It's an extreme option. When everything is falling apart and you have no hope, then think about bankruptcy, okay? Most of the time, people can look at that option and quickly get rid of that. But it is an option. Option number 2, you fight the lawsuit on your own. So you don't hire a lawyer. There's no lawyer expense. It also means you're doing this on your own. Now, if you're in Alabama, I have all sorts of resources I can give you to help you do this on your own. But still, you have to stand there on your own. You can't have your spouse in there arguing for you. You have to stand there in court and do this on your own. And my dog apparently is encouraging me to hurry along here. So we've got the first option is bankruptcy. Second option is you fight this on your own. Third option is you settle it on your own. Okay. So again, you don't hire a lawyer. You go to Portfolio and you say, what will it take to settle this? Typically, when you're in litigation, they're looking at 85% in a lump sum, maybe a few payments. And keep in mind, there can be tax consequences, and it may stay on your credit report. Now, as I'm recording this, Portfolio typically removes it once you pay it, but you've got to get that in writing from them. Don't assume that. Okay. Now, what's your 4th option and your 5th option? Those options are you hire a lawyer to fight it or settle it. The downside is you're paying a lawyer fee. The positive is if you hire the right lawyer who knows what he or she is doing, you should come out better on this. And that's a question to ask. Okay, here's the fee. How much am I paying Portfolio? Now, in my office, it's very easy. We don't pay them anything. Okay, but you may go to a lawyer that says, hey, pay me this fee, and we're going to pay Portfolio 50 cents on the dollar, 33 cents on the dollar, whatever it is. Like, just figure that out. Is this a good deal for you? What about taxes? What about credit reports? What's going to happen? And what is the lawyer going to do for you? If there is a trial, do you need to be there at trial? Or does a lawyer not want you to be there at trial? Maybe 1 out of 200 cases, we want our client to be at trial. It's very unusual. Normally, we do not want our client there because honestly, you have no way of testifying, no personal knowledge about did Synchrony Bank sell this to Portfolio or not. You have no idea of whether that happened or not. So you just be in there guessing. So we don't want you there. Portfolio has to bring a witness to properly testify. How do you get from the original creditor to here? How do we compute the amount? How do we apply the interest, the late fees, the over the limit fees, the payments, the credits? How do we get to the specific dollar amount? They better have personal knowledge of that. Okay. So those are some thoughts for you on if Portfolio calls you, writes you, credit reports on you, or sues you. And I hope that this is helpful to you. And like I said, subscribe to our channel if you like these types of videos. And if we can help you in any way, just let us know, and we'll talk to you soon. All right, bye-bye.